Hi, it is Ron. I'm back. I thank you all for joining me again for the second installment of our discussion about litigation in the American system. We did a bit of an introduction in the first episode. Today I'm going to talk about the basics of how the legal system fits into our government. The United States government has three branches. This is not as common around the world as I think most of us expect. We're so used to hearing about it. But it is the way it was set up in our Constitution. Of course, the Constitution doesn't say anything about branches or three branches. It rather establishes the branches. Article 3 of the Constitution, which we will look at briefly, establishes the judicial branch. But we have to understand that government is by nature a law machine. Each state legislature was supposed to send 2 senators to the United States Senate from that state. About 100 years ago, we switched to direct election of senators, which was the beginning of the end. That does lead us to the next branch, the executive branch. That's the President of the United States and all the agencies and departments that report to him, at least in theory. The whole concept of the administrative state and its metamorphosis into what has been called the deep state is that these agencies have long ago stopped being accountable to anyone, either the legislature that has created them and continues to fund them, or the chief executive who is putatively the boss of all of them. What we saw during the Trump administration is that these agencies hardly have any interest whatsoever in what the president tells them to do. They do what they want. This is a problem. This is a fundamental undermining of the Constitution. Talk a little bit more about that. After the Constitution was ratified, a case called Marbury versus Madison held that the United States Supreme Court has the power to decide whether a law passed by Congress is constitutional. Now, there have been some scholars over the years that have said that this was a grave error, that this was not the intention of the Founding Fathers. But what is interesting to note at this point is that if the other components of the government at that time, if the legislature, if Congress found that objectionable, or they could have remedied the system that the Supreme Court maintained was the system by enacting a constitutional amendment, which, if the Supreme Court were wrong, presumably would have easily been ratified, stating that interpretation of the law is one thing, but declaring a law unconstitutional is not the province of the judiciary. What does it mean for the Constitution to limit the powers of the government, which it does throughout, if the ability to ascertain whether those limits have been breached is not subject to review by the judiciary? If not the judiciary, who then? Section 1 of Article 3 establishes that the Supreme Court is the only court required by the Constitution to exist, and that the judicial power is vested in the Supreme Court. That's an interesting terminology. And in such inferior courts as the Congress may from time to time ordain and establish, that judges hold their offices during good behavior, spelled British style. Let's remember that the Founding Fathers did in establishing the judicial power was based on the Anglo-Saxon judicial tradition. I'm not saying that the spelling necessarily leads to that conclusion, but it does remind us that the American legal system does not exist ex nihilo, that it was based on and meant to be an improvement on the judicial system that was in place in the British Empire. This is the Constitution of the United States of America. The states, each of them, came into the system and retained their own judicial systems. I'm sitting here in Foley Square at the court hearing that I was scheduled to go to was postponed. That happens, it's part of litigation. But it did seem to me that this setting would be a very good one for me to explain something that a lot of people are confused about, especially overseas, which is the difference between federal and state courts in the United States. You can offend both sovereigns, even though the Constitution prohibits double jeopardy. you can still be held responsible for violating, for example, a state law prohibiting assault or terroristic conduct, and at the same time, federal civil rights laws for violating the civil rights of the person you assaulted or intimidated. And it has the potential to be very interesting to see which states' laws will apply. And there is actually something called jurisdictional arbitrage, by which lawyers map out what states' laws would be most favorable to apply and try to work out ways, sometimes it's called forum shopping, and that's what it is, to engineer the application of that state's laws to a pending dispute. That's part of the fun of what we do. So that covers